Any
Yes.
mention?
No mention DB. Okay, yes.
Any mention?
Lord, I beg to mention item 25, my lord. I require some instructions in this matter. If my lord, this 25, my lord. This relates to Malai Somat's aimship, my lord, and the bill, the act for the same ship is in the pipeline. So I require for this aimship, my lord, appointment of same and the link doors.
Who's with the other side?
Mr. Kanta, my lord, I've informed him.
Informed him?
Yes,
okay. As the counsel, the petitioner needs further instructions. This is matter of 2 weeks, yes.
Let it be 4 weeks, my lord.
Okay, 4 weeks.
Deeply.
Lordship, I beg to mention item number 17.
17.
17 to 21, these are all connected matters, Lordship.
Why? Oh, Dr. Mosika is
Yes, Lordship. He is on
out,
sanction
yes.
leave.
Mr. Chanda?
No, Lordship, he is
My lord,
V. Kumar.
hi.
Sir, V. Kumar.
Come
V.
up,
Kumar
my
is
lord,
the
my lord.
other side.
Oh, Mr. Kumar?
After 2 weeks.
Well, I am in item number 18, 19, 20 and 21, my lord.
18, 19, 20, 21. Then who's there in item
Yes, my lord.
number 17?
17, I am appearing, my lord.
Okay. After 2 weeks?
After 2 weeks.
After elections? After 2 weeks?
My lord.
After election.
Okay, yes. 2 weeks. 17, 18, 19, 21.
Lordship, I have a similar prayer for item number 26. With the consent of the petitioner, Lordship.
Where's the petitioner?
Lordship, consent has already been taken.
He's not there.
Yes.
Mr. Suna. 1 week, yes.
Highly obliged.
Yes, Lordship, I beg to mention item 31.
20?
31, Your Lordship. Your Lordship, the conducting counsel is indisposed. I pray for 2 weeks' time,
Who's
Lordship.
calling counsel?
Mr. Gautam Kishore.
Lordship, there is a stay of the proceeding. This is
Yes.
a POXO matter. That
Yes,
is the only.
after 1 week, positively.
Lordship. Apply.
Have you filed affidavit making
No.
allegations? Why? That means you have no allegations. Because you made allegations against a judicial officer. That's why we have to examine that. Yes.
Apply, Lordship.
Yes.
May it please, Your Lordship, I beg to mention item number 23, Your Lordship. I humbly pray, Your Lordship, that the matter may be listed after 2 weeks, Your Lordship.
We're making a joint request, Lordship.
1 week, yes. 1 week.
Lordship.
Should I like to make a mention for item 29, Your Lordship? So, senior counsel is having some personal difficulties, Your Lordship, today. So.
1 week, yes.
Apply.
We all are campaigning for elections.
No, Your Lordship.
Then
Let it be after 3 weeks, then, Your Lordship.
that's all right.
3 weeks. Apply, Your Lordship.
I 2 weeks.
Similar prayer for item 32 as well, Lordship.
22.
32, Lordship.
32.
32, Lordship.
Goes for the petitioner. You informed him.
No, Your Lordship. Will we inform, Your Lordship?
You inform him first.
Yes, Lord.
Then let me call out. Yes.
We have Lordship.
Not informing other council. No, no adjournment. Yes.
Supplementary list item number 1.
May I please the Lordship? This is the 4th time I am before this Honourable Court, my Lord. Now, my
For
Lord,
the state. Yes. You're for the state. Yes.
my Lord, this is the 4th time I am before this Honourable Court, my Lord. What happened?
4th time?
4th time, my Lord. My Lord, 2 writ petition was there and 1 review, my Lord. So subsequently, what happened, my Lord?
I'm sorry.
Subsequently, what happened, my Lord? I was arrested. Now, my Lord, I have filed a charge sheet. My name has not been included, my Lord. I have been discharged from the list of the accused, my Lord. I have written an application before the SF10 commandant, my Lord, to consider my application now, my Lord. They are not disposing of my application, only for disposal of my application.
No, when were you recruited?
I've been
When was the recruitment done?
the charge sheet, my Lord, may kindly see the charge
No,
sheet.
when you said you were recruited as in SF10.
Yes.
When were you recruited?
Appointment was given to me. I was supposed to join, my Lord.
When?
It was 2017, my Lord.
17.
17 years, my Lord.
7 years ago.
Yes, my Lord. Because now, what happened, my Lord, when appointment letter was given to me, my Lord, I was arrested in a murder case, my Lord. In a murder case, I was arrested and I could not join, my Lord. I obtained bail, my Lord. Thereafter, I communicate to the SF10 commandant, my Lord.
What was the last order of this court?
Yes, my Lord. The last order is in review, my Lord. The last order is in review. That is on page 46.
Substantive order before the review?
Before the review is page 30, my Lord, Annexure 8.
Before this bench only. What was the
Page 34, my
what
Lord.
was the conclusion?
If I'm just permitted to read, my Lord, para 9.
Para 9. Yeah.
In the instant case, it is not in doubt that the writ petitioner is yet to enter service and whose appointment is yet to be confirmed was arrested in connection with so-and-so, so-and-so. The judgment placed by the learned AAG on the same line will not allow consideration of the petitioner prayer as made out in the writ petition. It is also not a case where the petitioner was not given a fair opportunity to represent before the impugned order was passed.
Now
And
you
that-
say that situation has changed.
Yes, my Lord.
Now you've been discharged.
Yes, my Lord.
You take notice then. But Mr. SDN and counsel petitioner issue notice MSSI is Larry is present except notice behalf of respondents. No further notice required. This after 3 weeks for instructions affidavit is.
Item number 2.
Please, Lordship. This is the second round of litigation whereby in the earlier occasion, Your Lordship, I was court has directed to comply with the order saying that I have to register my land, and then as per the direction is very clear in the page 23, paragraph 5. Just want to read it, Your Lordship. Not necessarily go to the history of the case, but page 23 of the petition, paragraph 5.
Yes.
Here it is very clear that in view of the matter, this court is consider view that this matter can be closed and disposed with a direction to the party, especially petitioner, to complete the required formalities as provided in the office memorandum to enable the state respondent to accord regularization of service of the petitioner against the said post. With the above noted direction, this petition stand closed.
Mr. P.T. Sama, if you notice, Ms. Ailing was present in
For all the state respondent, Your Lordship,
all
1, 2,
respondents,
3.
no further notice called for. Just after 3 weeks is for instruction activity. Yes.
Lordship. Most blessed, Lordship.
Item number 3.
Please, Your Lordship.
Once again, Mr. Dubey, let the file come. Yes.
May it please Your Lordship. Lordship, before my friends start, Your Lordship, if I may request, Your Lordship, can you take up the next matter, item 4?
Why?
Because, Your Lordship, in that item 4, Your Lordship, the circular of the issued by the RBI was challenged in various High Court, and a transfer petition has been filed by the bank, by the RBI before the Honorable Supreme Court. There is an order passed by the Honorable Supreme Court that the challenge to this circular, Your Lordship, will have to be heard by the Madras High Court, Your Lordship.
That's correct.
Correct.
Therefore, we have filed 2 writ petitions, plus.
First one is for?
For challenging the circular.
Second one is for?
Second one, the consequential actions, as well as the other grounds which we have taken, that the amendment of the bylaws is contrary to the Act. In fact, they don't have any jurisdiction.
If all the matters will be heard by Madras High Court, then can this court take up the matter or not?
Yes, in respect of the first case, in terms of the direction by the Honorable Apex Court, that need to be transferred to the Madras High Court.
Okay, yes.
So for a second cause of action, my survives, that Your Lordship can take up.
In this first petition itself?
Yes.
What's second cause of action?
Second cause of action is we have challenged the...
So tell me, okay, you tell the court, what is the matter about?
Yes, my friends, if you Lordship may
jump the
permit,
gun, yes.
2 minutes, I'll just indicate the background of the case.
Take as much time
The petitioner is a CEO, MD. He's a postgraduate from Indian Institute of Management, Lucknow. Now, in 2019, RBI issued a circular in which certain eligibility criteria were framed, and those eligibility criteria were incorporated under the bylaws and staff rules of the bank. So, they become the guidelines of the bylaws itself. Now, in terms of that, I was appointed. My appointment was also approved by the RBI. Thereafter, what happens, an amendment was made to the Banking Regulation Act in 2020. And in 21, after my appointment, a fresh guidelines was issued by the RBI. That has been put to challenge, saying that, since there was a conflict between, since it's a cooperative bank, there has to be 2 guiding principles are there. One under the Cooperative Act, and the other, since it's a bank, RBI. So there has to be harmonious constructions. There were a series of cases all across the country, in which, in some of the cases, the Act was challenged. In some of the cases, circular was challenged. In some of the cases, both were challenged. So far as circular is concerned, there has been granted stay orders by various high courts. Even the RBI admits that there is a stay. And, since transfer petition was filed before the Apex Court, the Honorable Apex Court has directed that all these matters, and in fact, future litigation also before any High Court, that's to be transferred for adjudication so far as circular or Act is concerned to the Madras High Court. Now, relying upon that circular, the board has taken a decision to terminate my...
Where's the decision?
My Lord.
Why? It means the circular has made you ineligible to hold the post.
Yes, what happens, under the bylaws, I am a regular employee under the JET category. I am entitled to superannuation. I have my disciplinary proceedings are under the rules. Now, what the circular says, that my tenure would be 3 years. Then again, I am to entitle for appointment.
Where's the decision minutes?
My Lord, may I show to your Lordship the circular first, my Lord?
Yes.
My Lord. Annexure 7, Lord.
Page.
Page 55, my lord.
Yes. June 25th, 2021.
Yes. My lord will kindly come to page 56.
Yes.
Clause 2.2. UCVs have appointed CEO with prior approval of the reserve in terms of so and so may continue with the CEO so appointed till completion of her tenure or for a period of 3 years. Now under 4.1 also, my lord, the tenure has been curtailed down. Service conditions have been curtailed down, my lord. And based on this, my lord.
So how long you occupied this post?
My lord, 3 years only has happened.
Your 10 years ending now?
Yes.
As per the circular?
As per them, 30/11 is my cut-off date, my lord. And if your lordship would kindly see page 89, my lord. It's the minutes of the board meeting, lord. Your lordship would kindly see agenda number 7. At page 93, my lord.
Yes.
Bottom, my lord, report of the nomination and remuneration committee. But in terms of that circular also, this committee is formed, my lord. The chairman of the bank placed the report of so and so, so and so, so and so. The chairman read out the report that the required information, it is resolved that NRC will hold it next meeting so and so after the following suggestions. Your lordship would kindly see that the incumbent CEO was appointed by the board of directors so and so, so and so, and the same was accorded based on the date of appointment. His tenure of 3 years will be completed on 30th November 2023. And my lord, at the bottom.
23.
Yes, 23.
It's already over.
Yes, in terms of this honor, it's over.
This board was taken. This was taken when this board meeting?
On 9/11.
Last year.
Yes. Now what happens?
It's not been not been implemented as yet.
No, because there is a requirement of taking RBI's approval.
Okay.
And that your lordship find at page 104, my lord.
You sent for approval.
Yes.
Okay. Okay.
This is basically they are asking, page 105, your lordship would see.
For the general prayer.
Yes. 104, 2 aspects are there, my lord. Even for termination of my tenure as well as appointment of temporary. And now, okay, my lord, the circular also says, and now your lordship would see kindly the letter dated 29/11 at page 127.
Yes.
Well, this is the response from the RBI, my lord. At clause 7, next page, my lord will kindly see. Accordingly, you are advised to withdraw the order number so and so regarding removal of CA immediately and maintain status quo regarding the position of the CEO.
Okay, that's all right then.
So, my lord, but they are not allowing. Yes, I am safe, but they are not allowing me to function, my lord.
Why? The board?
Yes, my lord. They have even lodged police complaint. They have taken away my vehicles.
Where have you made that pleading in your writ petition?
Well, the other writ petition where I have challenged this circular.
So it becomes a personal case for you.
My lord.
Apart from the circular, it's become a personal case for you.
No.
Against the board.
The consequences, blood, because I have a locus. Your lordship.
Yes. Where's the order of the Supreme Court?
First, may I show your lordship's High Court's order, my lord?
Yes. So just go through once enough here. Where show me the order of the Supreme Court.
My lord, will page 160.
If our hands already tied, that means what's the point? Yes. 160 is some Andhra Pradesh.
Sorry, my lord, 168? 168 it is.
168, your lordship.
168.
168.
Yes.
This one, 168.
And 169, if your lordship would see. We accordingly direct in the middle.
1 second.
All the writ petitions which have been filed before the High Court challenging the validity, Act and or circular stand transferred to the High Court of Madras The petitions which are preliminarily transferred to the High Court have been set out in the chart. There is a chart annexed to this order, my lord. Now, your lordship would kindly come to next page.
Where's the chart?
Before that, page 170, if your lordship kindly come. Second last, any future petition challenging the validity of the amending act or circular noted above, upon being instituted, shall be transferred immediately by the concerned High Court to the High Court of Madras. In view of
Take
the-
down then. First, we'll transfer this matter.
Yes, my lord.
Then the other asking consequential relief in the secondary petition.
Yes, yes.
But will that not be, parallel, exercising parallel jurisdiction?
No, my
If
lord.
you're seeking
My
relief,
response
you have
submission
to
would be-
satisfy the court.
yes.
Let's take up the matters.
Yes.
Let's finish this matter first.
Yes, yes, my lord.
Yes, this writ petition has been filed assailing the circular dated 25/6/2021 issued by Reserve Bank of India regarding appointment of Managing Director (MD) stroke whole time director (WTD) WTD in primary (urban) cooperative banks. Stop. At the outset, Mr. R. Dubiel, counsel of petitioner, has submitted the impugned circular have been put to challenge in various high courts of the country and has drawn attention of this court to order dated, this is Supreme Court order dated?
Supreme Court is dated 14/10, my lord.
14/10.
2022.
22?
Yes.
14/10/2022, passed in transfer petition (civil)
14/12
numbers 659-678/2022 by the Supreme Court of India. Stop. Next part is, he submits that by this order, all similar matters challenging the validity of the Banking Regulation Amendment Act 2020 and stroke or the circular dated 25 June 2021 shall stand transferred to the High Court of Madras. He therefore submits that as this petition is similarly situated, directions be passed for transfer of the incident matter to be heard by the Madras High Court. Stop. Next paragraph. Mr. Andy Shura Island AAG appearing with so and so does not dispute this and has concurred to the submissions. 4 and 5.
Lordship, yes.
4 and 5 has concurred to the submissions made by the petitioner, learned counsel for the petition. Stop. In this view of the matter, this court has heard the counsels and perused the order dated 14/10/2022 passed by the Supreme Court in the aforementioned transfer petitions, as well as the pleadings in the petition. Stop. It is correct that the same circular is under challenge in the present petition. Stop. Next paragraph. Accordingly, WPC number 109/2024 shall stand transferred to the Madras High Court as directed by the order dated 14/10/2022 of the Honorable Supreme Court. Matter to be listed awaiting the outcome.
Lord, I am praying for the interim prayer, my lord, because similar interim prayers have been granted by various high
Yes.
courts, my lords. So, my lord, I pray that the circular may be stayed, my lord.
Yes, next paragraph. In line with the orders passed by the other high courts, the impugned circular dated 25 June 2021 shall remain stayed till disposal of the writ petition. Yes.
Deeply obliged, Mr.
Item number 4.
So what should we do this matter? This next one?
My lord, here, my lord, kindly your lordship would see page 245.
No, 245.
Yes.
The last page.
Yes, my lord. It's subsection 4, term of board of directors, my lord.
Yes.
My lord will see the board of directors elected by the General Assembly shall hold office for a period of 5 years from the date of election
Yeah.
or date of functioning of the board. My lord, this incorporation date of functioning of the board is contrary to the 2015 Act, my lord. I have the bare Act as well as I have quoted in my writ petition, my lord.
Yes.
If your lordship kindly come to page 38 of my writ petition.
Term of office, term of
Yes.
board directors.
First is term of board of directors. Lordship has seen the amendment. Then the provision of the Act is para 2064.
1 second.
Yes, my lord.
Right, and 64.
64, your lordship would see subsection 3 of 33. The term of office of elected members of the board and its officers shall be 5 years from the date of election. So by making an amendment, my lord, they have themselves extended their tenure, my lord. The bylaws cannot override the Act, my lord.
What does the Act say?
But this is the Act, para 64.
Yes. The section 33, 3 of the Meghalaya Colony supplies the term office shall be 5 years of the election and term office shall be.
And election was held on 29/6/2018, 27/9/2018. So there.
So by this writ petition, you're seeking to remove the whole board.
Yes, but because I have a locus, what we say that the impugn order is without jurisdiction. And in fact, there are observations by the, my lord, RBI also, my lord. Well, just I'll show from here. Kindly have page 188, my lord.
Who's appearing for the board?
Well, I think notice has to go to, my lord. My lord, in the interim, my lord, I should be allowed to continue, my lord, because the ad hoc, my lord, arrangement is also, my lord, who doesn't have proper, my lord, qualification. Lord, I am a person who had been in banking sector for last 20 years, my lord.
So this is a personal case to you only.
My lord?
Personal to you only, and your service, whatever have oppression you think is happening.
Yes, yes. Now, because of that stay, my lord, I should be allowed to continue.
Yes. This address to whom? Who's Ratul Atakar? Section 118, you said?
Yes, page 188, my lord. This is a minutes of the meeting, my lord. And your lordship would see the meeting.
189 is the?
Yes.
Reserve Bank of India?
Yes, Reserve Bank of India.
Yes.
My lord, what your lordship would see, what the observation is, not following due process, forceful removal of CEO.
Where is that forceful
removal? Page 189, clause 1, discussion. DGM NK highlighted the issues related to governments not following due process in recruitment of 3 staff members.
Where are you reading from?
My lord, 7, page 189.
Yeah, discussion on
B, clause B, my lord.
2 professional directors.
Yes, and not following due process of recruitment of 3 staffs, 2 professional. C, my lord, forceful removal of CEO and non-appointment of a regular secretary, despite RBI instructions. My lord will see, despite RBI instruction to the chairman to maintain status in the position of other B is thoroughly examined. The same has not been adhered to. And in next page, your lordship would kindly see, at page 19, last 2 paragraphs, just 1 column your lordship would see. However, it is imperative to mention that the circular rebid is on hold as per Honorable High Court's order. And in their 2911 letter that your lordship has seen, my lord, when they sought approval, they have directed them to withdraw that letter. In fact, RCS has also so-caused me to the board also, my lord. And my lord, kindly your lordship would see in what manner I had to hand over my vehicle, my lord, 202.
Who's RCS? Register of Corporate Society?
Registry of.
Yes.
page 202, your lordship would see. The witness of this handing over is the officer in charge of Jowai PS. Because if I would not have handed it over, I would be arrested.
So there's a personal grudge against you in the bank?
Yes, my lord, what has happened, my lord? There were 3 appointments. Two of the relatives of the board of directors, my lord. That I have also pleaded, my lord. That triggered the entire thing, my lord. I have nothing personal, my lord.
Two handing over vehicle, office keys and laptop.
Yes. At the bottom, your lordship would see officer in charge, Jowai. Yes. He accompanied me so that to ensure, my lord, I hand it over. Otherwise, I would be somewhere else.
Okay. Let them appear. We'll hear them. It's heard, Mr.
Only thing I should
Abdul
be allowed to continue. Their board and all, my lord, RCS will take into. Just I have brought
Yes,
to your
sir.
lordship's notice.
Heard Mr. Adube, counsel for the petitioner, with so-and-so, with so-and-so assisted, issue notice. Mr. Shrai.
1, 2, 3, your lordship.
Mr. Shrai, additional AEG, with MSR Kohli is present on behalf of the respondents 1, 2, 3,
your lordship.
So no further notice called for respect respondents. Petitioner to take steps for issuance of notice to the remaining respondents within 3 days. Stop. Next paragraph. The grievance of the petitioner, as set forth in the grievance of the petitioner, is that grievance. The petitioner for this court prayer for directions. Decision of the board's 20. It's dated 9/11.
Yes, my lord.
So, termination letter dated? Where's the termination letter?
My lord, 21/11.
Where's that? 20?
I think that I have been close. It's page 127, my lord.
127?
Yes. 145, my lord. I'm so sorry.
One?
Board resolution. Other petition. Which one? Yes, yes, it has been.
Yes, yes. Next year 24.
This is a board resolution.
The board is court saying decision of the board of directors.
Yeah, it's there.
To terminate.
My lord will find it at page 142, my lords. I'm so sorry.
142? Oh.
Yes, yes. That gentle reminder letter.
No, the gentle reminder letter is different. It's addressed to Reserve Bank of India.
Yes.
This is the one.
That addressed
now
to me. Yes, my lord.
Where's the address to you?
Page 140.
Mr. Dubey, please. This is the code. Where's one is addressed to you? Is not annexed?
My lord, a copy has been marked to me, my lord.
Where is that?
My lord, at page 162, your lordship would see annexure 126. This is addressed to me. 2811.
You said 22nd 11 even terminated.
27 terminated because they have taken a decision on board 9/11. They have written to RBI for granting sanction and they have intimated.
No, this is from the Reserve Bank, where you express the displeasure 166 with your removal.
162, my lord.
Okay. You're confusing the court, yes. terminate his services as CEO of the Joy Cooperative Urban Bank Limited. Stop. It has been submitted that the decision of the Board of Directors to terminate his appointment as CEO of Joy Cooperative Urban Bank is violative of the violative of the, where's the letter?
2911, my lord.
The letter of the RBI.
166.
Is contrary, not violative, is contrary to the letter dated 29 November 2023, wherein the Reserve Bank has expressed its displeasure on the removal of the CEO stroke MD of the bank. Stop. Next paragraph. Mr. Adube at this stage has prayed for some interim protection, inasmuch as he submits that the Board of Directors not allowing him to function as CEO, and he has been made to return the articles. Files also?
Yes, my lord.
Articles and files. To the board or to whom?
To the Deputy CEO.
To the Deputy CEO. Stop. It is further submitted that in view of the interim orders operating with regard to the qualification and tenure of the CEO, it was incumbent upon the Board of Directors to allow him to continue without any hindrance. Stop. Mr. Shulai.
Lordship, in my humble and respectful submission, Lordship, if the prayer made, interim prayer made, Your Lordship, then it will amount to final disposal of the writ petition, Your Lordship. Lordship, at least notice may be issued. Let them have a say, Your Lordship.
Yes, let them come.
Lordship, in that case, my lord, they will not appoint any new fresh. No, that at least protection to my post should be there.
Mr. Andy Shulai, LLAG submits that the matter, as a matter concerns the bank and the petitioner and the
Lordship, yes.
bank itself, the state respondent is not in a position to counter the prayer for interim, to counter the prayer for interim protection or to seek any directions. Stop. He always submits that grant of interim prayer at this stage will amount to granting of final relief. Stop. I have heard the counsel for the parties. It is correct. It is noted that the main prayer in the writ petition is directed against the action of the respondents number, that is 5. Both directors.
Yes, fine.
Oh, you can write 4 to 6. With regard to, was that, sorry, problem done? 4 to 6.
It should be 4 to 7, Your Lordship.
4 to 7.
Oh, 4 to 7, Lordship.
4
Yes.
to 7. Yes. In that view of the matter, before any orders are passed,
can I pray for notice on interim prayer also? My
yes, this court deems it fit that notice and interim prayer be issued to the said respondents for consideration on the next date. So, however, is provided that till the next date, there shall be no appointment, such appointment to the post of CEO. When you want to list it?
Only, may I submit, Your Lordship, if already made, then this order will not be
RBI was directed for maintaining status quo.
If the order of the letter RBI is like that, they can't go against it.
Lordship, yes. Certainly.
So anyway, they have to undo it. When?
As per Your Lordship's convenience, my lord.
After 2 weeks.
My lord. Can I have a fixed date, my lord? Only
Take it from the court master. List the matter for consideration and interim prayer on the next
Apply,
day.
Your Lordship.
I'm so deeply obliged.
Apply, Your Lordship.
Item number 5.
Yes.
Yes, Lordship. Lordship, in view of the elections and the rules, Lordship may pass orders for directing the respondent to approve the VEC.
You took instructions.
Lordship, I went through the rules and there's no rule stating that the signature.
It's mandatory that signature of the headman should be in a social agreement.
Lordship. Because as per the contract which was placed, Lordship, it stated that.
In the recital of the contract between the video parties, video and the secretary and the chairman. Video is first part, and the second part will be the secretary, elected secretary and the president, Lordship.
Where's that?
That is in the counter filed by the respondent, Lordship, page 9, Lordship.
If I can take your Lordships to page number 10, point number 2, Lordship. Of the,
One second. Page?
Number 10 of the counter, Lordship.
Yes.
Point number 2.
Yes.
Lordship, the point number 2 would state that the village employment council consists of every male and female heads of all households in the village. Full stop. There shall be elected member from each VEC, including the traditional headman and the female member. Lordship, this was cited from the 2006 NREGA scheme, Lordship, and this was amended by the notification dated 2010, Lordship.
Where is that?
Lordship, at page number 13 of the repetition, Lordship.
It has been amended.
Yes, Lordship.
Now the headman is not required anymore.
No, Lordship.
Page 13.
Lordship, of the repetition.
Yes.
At point number 1, Lordship, may I read?
144.
Page number 13, annexure 1 at
Yes.
against para 7A clause 4 sentence.
Yes.
There shall be 3 elected members from each VEC, including a traditional headman and female member of the represent VEC at AAC. Will be replaced with each VEC will have a program executive implementation committee to implement the scheme in the village. This committee will comprise of 5 persons conversant with the NREGS Meghalaya, out of whom a chairman and secretary will be elected. Chairman, secretary, and 1 member will be.
Okay, but then why was social agreement drafted as per the old, as per the old orders, old act?
There is no need. In
Most
fact.
probably it hasn't been changed as in accordance.
No, but the BDO should know that if he's implying those schemes, then what is the current act, what's the relevant act operating?
Lordship.
And we will dispose of
Lordship, that is why I have enclosed the order issued by the Shalsala block, where the 5 members were approved by the concerned BDO, Lordship. That is the process, Lordship.
Not understood. No, Ms. Karonlang was opposing last time because that was not known to him.
Yes, true, Lordship.
That was the instruction they received. Yes, take down.
And in fact, I had that constitution of the PEC, I have copied in my rejoinder, Lordship, that from the amended rules, Lordship.
Stop. This is second round of litigation.
First round of litigation, Lordship, I came because the election was not held, despite the expiry of the term, Lordship. Then I approached. After that, court has directed to conduct the election. Accordingly, the election was held.
Where's the last order of this court?
Lordship, can have at page number 23, Lordship.
Page?
Page 23, Lordship.
23.
23.
Yes, the writ petitioner, by way of the second round, by the way of this, is before this court. In this second round of litigation, praying for directions for approval of the Village Employment Committee, which was elected on 29/8/2023. 2023. 2023, correct?
23, Lordship.
23, stop. In the earlier round of litigation, Stop. The writ petitioner had approached this court seeking directions for holding of elections to the Tungruchar, TUNGRURCHARVC, under the zigzag ZIK seen at the block Southwest Garo Hills. Stop. The elections thereafter were conducted on 29/8/2023. And the petitioner was elected as the secretary of the new VEC. Stop. However, after the said elections, no approval to the new VEC had been granted by the respondent before, which prompted the petitioner to approach this court again by the incident writ petition. Stop. Next paragraph. It has been submitted. In the course of this matter, it appears. For the matter, it has been submitted by the counsel for the state respondents that the non-approval of the VEC was due to the fact that the signature of the village headman in the social agreement formed had not been obtained.
Lordship, may I please add? Lordship, initially the VEC was not approved because several complaints were received.
Okay, Tom, that firstly the VEC was not approved due to numerous complaints that had been raised with regards to Constitution, and further that the signature of the headman had not been obtained in the social agreement form. It was submitted at that point of time that as the said VEC was, what was the word you can use? Was not being able to function. The voluntary function, the powers, was not allowed to. Tom, no? As the VEC was not able to function, the BDO had assumed charge over the same. Stop. Next paragraph. What do you see, Ms. Isi Sheikh? Inquiry was done. Where's the inquiry?
Lordship, that is at.
That is said that the elections are free and fair?
Yes, Lordship. That
Where
is at page 35, Lordship.
Of your writ petition?
Yes, Lordship.
Yes, 35.
Yes, and the operative part will be 37, Lordship. Findings.
Yes, next paragraph. Ms. Isi Sheikh has submitted that the grounds as set up by the state respondents for non-approval of the VEC were unsustainable, as an inquiry which had been conducted by
the ombudsman,
the OMBUDSPRSON, ombudsperson bracket capital MGNREGA close bracket Southwest Garus Ampati Meghalaya, had conducted an inquiry, and had filed a report stating that the election of the president and secretary of Tungrul Char VEC was held peacefully and no unfair means were used by the winning candidates, and that the result of election was not illegal. Stop. He therefore submits that, he further submits that the second ground as set up with regard to the signature requirement of the signature of the headman is non-existent, or is not a point in issue, in as much as the same as per
the amended rule 2010.
The amended rules of 2010 has been done away with. Stop. Next paragraph. Mr. H. Karnavarlang, Leonard GA, in reply has submitted that the social agreement that had been prepared inadvertently. Where's the social agreement?
That
Lordship,
is
is
in his
that my
counter, Lordship.
counter, Lordship?
Oh, yes. The page 9.
Page number
The
9.
social agreement which had been drafted at clause 2 had inadvertently included the clause whereby there were to be 3 elected members from each VEC and 2 individual headmen. Stop here, however, fairly submits that with the amendment of 2010, the same has been done away with. Stop. Next paragraph. I've heard the counsel for the parties. Stop. In view of the submissions of the counsels as noted here and above, both the points in issue or the objections to the approval of the VEC as on today no longer exist, as can be seen from an inquiry report furnished by the Ombudsman and also the
amended rule 2010.
The amended rules of
2010.
Wherein it has been provided that, where's those rules?
Page number 13, Lordship.
Page number 13. When it's provided that quote at section 1, where it has been given at para A.
7A, Lordship.
7A, Lordship.
Against a 7A, clause 4, the sentence, I within inverted commas, there shall be 3 elected members from each VEC, including the traditional headman and female member, to represent VEC, capital at AEC, close quotes, will be replaced with open quotes again. Each VEC will have a program executive stroke implementation committee to implement the scheme of the village. Stop. As such, in view of the discussion here and above, nothing remains further of consideration and deliberation, and the same is closed as per the direction that the respondents shall accord approval to the duly elected VEC of Tung Gurchar block, village CNRD blocks also, within a period of 3 weeks from today. Yes.
Daily list item number 1.
Yes.
May it please your Lordship.
Yes. Regularize.
Lordship, the latest update we've had is that it's still under consideration, Lordship.
He died.
This is still his, yes, that husband died is the wife, Lordship. Yes, he died. The disease died. File.
Which department?
This agriculture.
Agriculture, Lordship.
Agriculture.
Is under consideration from the personal department right now, Lordship.
Where's the instructions? You got any instructions?
Lordship, last time we had informed this honorable court that his name is there, Lordship.
Name is there, not enough.
Lordship, but then the latest instruction we've had in this same month, the month of April, Lordship, his name is under consideration, Lordship.
What do you mean consideration?
Consideration for regularization, Lordship.
This annexure, see page 28 of the writ petition. This is 2nd March 2023, over a year ago.
Lordship.
Yes. So I rested at that, now still the same stage.
Lordship, there are other departments to be considered, whereas the latest we've received is from the personal department, Lordship.
It's pending which department? Have you filed affidavit? You file affidavit. The order will dispose it of now only. Oh, he's died since 2020. This is the kind of instruction.
That is just additional information, Lordship. That's not instructions, Lordship. We were seeking information.
Today, MS NG Shalala, same advocate, so and so, has produced a letter dated 2nd April 2024 with regard to the status for consideration and realization of the husband of the writ petitioner. The same is cryptic and in 5 lines without clarifying at what stage the matter, at what stage of process, at what stage the letter is cryptic and consisting of 4 lines. I don't disclose at what stage the consideration, at what stage, it doesn't disclose any other details, stop, with regard to the process of realization of the other petitioner, stop. State to file affidavit within 2 weeks, yes. File affidavit, otherwise those are not instructions.
Much obliged, Lordship.
Please, Your Lordship. Lordship, the respondents are yet to file their affidavit. They had filed and then withdrawn due to some error.
Lordship, I am praying for further 2 weeks' time, Lordship, to file affidavits.
When do you pray first for fresh affidavit?
Lordship, this was for
since
12th.
October 2023, it was moved. And
fresh
then
affidavit?
12/3/2024 affidavit was withdrawn, Lordship.
12?
March 2024 affidavit was withdrawn.
14 March, the withdrawal order is there, my lord. 12 March, they had filed the affidavit, and thereafter they had withdrawn on 14th of March.
When will you file it?
12th March, Lordship.
When? By
After 2 weeks, Lordship.
Because it's a construction matter and the contractor and all they are...
Construction matter?
Yes, my lord. It's a construction matter.
Regarding?
The Union of India is not allowing the petitioner to construct any house on the land purchased by the petitioner.
They need an affidavit then.
My lord, so far as the state respondent is concerned, my lord, Annexure 5 and 6, my lord, that will suffice the state's, my lord, stand. Here we have already stated there was an inspection, my lord, called by the Deputy Commissioner, my lord, and it was subsequently conducted on December 22. And in there, my lord, we have already stated that there is no encroachment in defense boundary. Point number 2, my lord. And in point number 3, my lord,
Let them file it, or then we'll dispose it of. Yes,
prayer is against the Union of India.
Leonard Council, Vice so-and-so, prays funds allowed further 2 weeks' time to file fresh affidavit. It is noted that the earlier affidavit has been withdrawn since 14 March.
Yes.
14 March.
Yes, my lord.
No, it's only 14 March. It's fine. They take a long time. So next param MSR only on behalf of the respondent
4, 5, and 6.
on proceedings 4, 5, and 6 has submitted that affidavit will not be necessary on behalf of the state respondents in as much as annexures
Annexure 5 and 6, my
5 and 6 of the petition itself is the stand of the state respondents. Or at least after 2 weeks.
Highly obliged, Lordship.
Item number 3.
My lord, so far as the state is concerned, we have already filed our affidavit. Except the private respondent, we have to file an
Yes.
affidavit.
4?
4 file.
5. 1 and 3 file.
Respondent number 5 is yet to file the affidavit, Your Lordship.
Why?
Your Lordship will file an application in the AG's office, Your Lordship, for the certified copy of the...
Here for the second wife.
Yes, Your Lordship.
What's in Kharso
He has to
Okay, Mr. Rinja submits that after we have 1, 2, 3. You filed it when? When?
No, we received on 5.
12.
5th.
12-4. Oh, 12-4 only. Yes, Mr. submits that on behalf of respondents.
1, 2, and 3.
When you filed it?
On the 5th, my lord. 5th of March.
5th of?
March.
5th of March? You haven't filed a jointer?
Well, I'm waiting for the private respondent as well.
Then you just write this Mr. A. Kharso, Council Respondent 5 prays for and allowed further 2 weeks time to file affidavit on behalf of respondent number 5. The affidavit behalf of respondent already on board. List after 2 weeks, yes.
Item number 4.
Taken steps already.
7 and 8?
Your Lordship, I'm entering appearance on behalf of respondent number 7. I'll be filing my file number
Who's 8?
No one, my lord. We have already...
No one. I mean, who's 8?
8 is candidates, my lord.
This is which election?
It's Sodar Ilaka Maulong.
Brenda Darling score?
Yes.
They're performer respondents.
Performer respondent.
They're supporting your case.
They were candidates, my lord.
So you're appearing for 5 and 6?
3 to 6, Your Lordship.
3 to 6, okay.
Already
You already filed affidavit.
Yes, Your Lordship.
Mr. Pasanthev submits that evidence on behalf of 3 to 6 has already been filed. Staff MSZ inquiry is entered appearance on behalf of respondent number 7 today. You want to file affidavit? No. She submits that no affidavit before coming from said respondent.
I'll file my rejoinder, my lord. I'll be filing my
With
rejoinder.
regard,
I'll file my rejoinder.
yes, with regard to respondent number 8, office code indicates that service not complete. Accordingly, this matter after 2 weeks for rejoinder and for appearance respondent number 8. You can obtain status if you want also.
Item number 5.
And for the appearance for report on service number 8. This matter of 2 weeks for.
This is a contempt petition, my lord.
Steps are taken.
We have received the notice, my lord.
Yes.
My lord, we'll be filing for Bagalatama, my lord, within the course of the day, my
You'll be
lord.
filing for
My lord.
not yet filed also.
Not yet filed, my lord.
You have to
I'm
comply
praying
the
for
order, my
2 weeks' time to file a reply to
You
this.
have 1 and 2.
1 and 2.
MS Adatas entered appearance on behalf of respondent 1 and 2 today and submits that the power be filed accordingly. With entered appearance on behalf of 1 and 2. So she prays for the Lord 2 weeks time to file affidavit, counter affidavit to the.
All right.
Yes.
Item number 6.
Counter affidavit. Taking. Affidavit ready?
Lordship, they had to file rejoinder, Lordship.
My lord, we pray 3
Rejoinder?
weeks.
Yes, Lordship.
My lord, the
On the part
respondents
of
have
the
already filed
petition.
their affidavit. We pray 3 weeks time to file rejoinder.
First time is, what's your name? Yadav?
H. Yadav, my lord.
With the pre-response allowed 2 weeks time for rejoinder affidavit filed by the respondent, live thereafter and so and so.
Item number 7.
Highly obliged, my lord.
7. 7 and 8. 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 7 and
Please, Your Lordship, we are still awaiting instructions, Lordship.
Regarding what, huh?
This is also
VEC matter,
Pension
Lordship.
matter?
No, no.
No, Lordship, VEC elections.
election. They are not holding.
The school is very sensitive to pension matters. Yes. No elections, why? Because of the pending Lok Sabha elections.
No, Lordship.
No, Lordship.
4 years passed already. They are not holding the election, Lordship.
How come no instruction been received since 1st of April?
We are awaiting instructions, Lordship.
It is noted that though the learned GA since the 1st of March had sought instruction, the same have not been forthcoming from the concerned respondents list after 2 weeks. After elections will be over, 2 weeks. After 2 weeks, yes. Instructions are we obtained positively for the next day.
7, 8,
Similar
9,
prayer for 8 and 9, my Lord.
and 15 also.
All terms over.
Yes, Lordship. And 15
positively
Lordship.
before the next day. These are small matters.
7, 8, 9 and 15 Lordship.
7,
8, 9 and 15.
7, and 15.
We are not there, Lordship.
My friend. Mazu.
Much
They
by
all moved
Lordship.
on the same day.
Pardon?
Were they all moved on the same day first?
No, Lordship. Wow.
Then there'll be
7,
different-
8, 9, 7, 8, 9,
Only
one
7,
day,
8
and
and 9.
15 is different, on different date, Lordship.
On?
Different date.
Same day, 7, 8 and 9.
7, 8, 9.
And 15 was moved when?
Move subsequently, Lordship.
On the? There's a date. Who appears there? They took
17
everything.
for Lordship.
It was done the month of
On?
March.
17 for Lordship.
17-4. Okay, 17-4. 17-4 is the other one. The ones are 1 3.
Not 17 for Lordship.
These matters were filed just in the month of February and March, Lordship.
1st of March. Now we're sitting in mid-April, yes, or end of April.
That one also filed on March only. I did not 15.
To get the date of the first from the order sheet.
I think 15th of March, was it?
1st of March, the other ones. Getting a number? 15.
February, okay.
The 2nd of April, yes. Got 6, 7, 8, 9 is 1st of March, and this 15 is 2nd of April.
Much obliged, Lordship.
Yes.
10. Item number 10.
My lord, the affidavit is ready. The only thing we're waiting for, there may be an update from the personal department, and since the staff is on election duty, we are unable to get that update.
Yes, this is regarding pension, Your Lordship.
This
Pension.
is regularization, madam. Regularization.
Yes, so-and-so praise funds allowed further 2 weeks time of affidavit. You already filed?
No, Lordship, we just received instruction.
Yes, MS Ivasa, company, Ms. S.I. on behalf of response number.
Respondent number.
1.
Number?
125.
125, and you for?
It's for 6.
It's MSSI 125 and EB Pasa for 6. They follow for the 2 weeks time to file affidavit. Yes.
11.
My lord, there's present petitions with regard to renewal of the societies, my lord, the association. And my lord, we have received a very simple instruction saying that the reason for which approval has not been given is because of a complaint by the members of the association. Now, my lord, this copy of the complaint was subsequently received, which shows that the previous, the body, my lord, the constituent members, all have resigned. Only the president, my lord, who is a petition before lordship, is the person who is standing. And he, along with his other friends, my lord, they have come before the office for renewal, my lord. So, my lord, that they have not been properly elected. So, no constituent members
There's no
have
vote,
been.
there's no resolution also,
So, there is a
election.
complaint, my lord.
And how will they renew?
My lord, if lordship
I have
wants
no
to peruse the
instruction with
complaint
regards
letter,
to
my lord,
this
we have
one,
a
but,
copy of the complaint letter.
Then you have to have proper elections, elect new members.
Let me get
Where's
a,
the constitution?
just,
Is here?
I will just get
Yes,
They have not
constitution?
included any of the
Where's the
constituent
constitution?
members, my lord.
Constitution it is there, lordship.
Where we annexed it?
What
Yes.
constitution?
Here it is.
Annexes 6.
Very good news. Names are all Garu Hills Archery Association. So how many archers are there in your association?
Constitution is at page 18.
Yes, I know. Where's the election?
No, my lord, there is no proper document to support that these are the people who have been duly elected by the members of the association, my lord.
I'll get the instruction, Lordship, because regarding this latest update, I don't have any instruction, but I have enclosed it, but what I got instruction is just because the respondent is not allowing to renew just on the ground that there was a case registered against that.
MS Art only on instruction submits that the non-renewal of the petitioners association by the registered societies. By registered societies?
My lord, yes.
By the that is the yes, by the registered societies is due to the fact that complaints have been received that all the members of the Garo Hills Archie Association have resigned from the respective designations except the president, and that the association stood dissolved. Stop. On these instructions, with the PT Sangma praise me not to obtain necessary information.
Lordship.
My lord, I'll share the copy of the complaint.
Yes,
so
a
my
copy
friend
of
can
the complaints has also been shared with the counsel for the petitioner. Just after?
After 2 weeks, Lordship.
2 weeks, yes. So it's already dissolved.
My lord, yes. So from where did these people come into
If
picture?
that is the case, I will withdraw, but after getting
not because of withdrawal, then you
will take the next.
Item number 12.
You know how societies operate. If they are dissolved, they have to go to another society which has similar objectives.
Yes, Lordship. What's Lordship?
Lordship, here I pray for some more time, Lordship, from this time.
Where's the petitioner?
Here this is the matter relates to change of nomination in the service record, Lordship.
Yes, Mr. S.A. Sheikh for respondents number 1 and 2. None appears of petitioner. Mr. S.A. Sheikh 1 and 2 and E.B. Prasad for 3 pray for allowed for the 3 weeks time to file affidavit.
13.
I have already texted up here a lot.
Office note indicates that steps there's notice not complete regard to the respondent number 4. Yes.
I am prepared 2 weeks time, Your Lordship, to file the
Mr.
affidavit.
Endraji, please funds out further 2 weeks time to file affidavit. What's the matter about?
It's a Kaubura matters, Your Lordship.
Government matter. Okay.
Much obliged, Your Lordship.
14.
At 14, I have taken steps upon respondent 6.
For 6 only.
Only for 6.
Yes.
Your Lordship, we won't be filing affidavit in this matter. Your
You already
Lordship.
said that, yes. Not recorded. Officer indicates that the service not complete on behalf with regard to respondent number 6 stuff. MSC now Cloud submits that no affidavit report coming from the response. This you take status or
We'll wait for his.
yes after 2 weeks.
Obliged.
Was service report on the status for number 6.
Hearing. Item 16.
This is the same case.
I tried to look through some judgments. Very difficult to get.
Of course, I've got some judgments relating to cadre. Change of cadre. So, of course, I've.
So to who can we put the blame on then?
Yes.
For a sad situation of the petitioner.
My lord, of course.
Shall he be made to suffer?
The office, some blame, of course. go to the office, my lord. That is there. But however, my lord, pertaining to cadres, I have seen, my lord, where, my lord, from a different cadre is been posted where he is not entitled to be. There I have seen some judgments, my lord.
But as per the imperial order also, they said I'm not entitled as per the rule. But what is the rule? In the imperial order also not quoted any
no,
rule.
that's why we asked for the
Rules,
rules.
my lord, instructions are
And
sought-
rules also he could not produce anything.
Instructions I have sought for the department, but they said that their only rule they are relying on is the 2017 rule, my lord. Now, prior to that, draft rules was there, my lord.
Draft rules have no meaning. Prior to that, I mean, it's just on the rule of thumb.
But
executive
the
instruction.
problem is that, my lord, even in the draft rules, my lord, this aspect is not covered, my lord. My lord, kindly allows me one last.
Last one.
My lord, relating to that cadre, if I am allowed to place it before the honorable court.
You get some analogy. The thing is that, see, he was allowed, then he was promoted.
Only the one question is that after
But
the retirement, he cannot be reverted back to the post.
But my lord will kindly see.
No, they're trying to fix a pension only from the pay drawn from the post you should have occupied.
My lord will
That's the only
kind-
thing.
my lord will
But
kind-
then they have said there's no question of recovery. So whatever additional amounts been paid to you, they'll not recover any of the amounts. Okay, they say which have been wrongly given to you by giving the promotion of senior driver, correct?
Driver.
Yes. Now the only thing is for fixation of your pension.
Pension, that
so
is
for
the case.
fixation of pension, they have an objection of finance department.
But
that
finance-
since he was not entitled to occupy that post,
But
so
under-
the fixation
under,
of your pension will not be at the last pay drawn.
But under what
be
rules
only-
also not quoted?
But that's the thing. That's why is this case pending for so long? Because court wanted to know from the government advocate whether these instructions are on what basis, and who will bear the blame.
My lord, otherwise, my lord will kindly see this, his appointment to the post of driver, initial post, is officiating. Promotion was given nevertheless, my lord, but still the fact remains that this was an
Whatever it
officiating
is.
post.
But it's a deemed regulations can be taken.
Poultry
And this
attendance
was
not
the-
equivalent to driver post.
This
Allowed him continue till
that
till
should
the
not have
retirement.
happened.
No, poultry attendance is equivalent or not to driver post.
No, there are two different posts, my lord. There are different posts. And poultry attendant will retire as poultry attendant, my lord.
But with rules, the rules required. Some rules are required.
Lord, this is as far as the instructions which I received from the department, my lord. They have no, there are certain posts, my lord, where there are no promotional avenues, my lord. They are born in that post and they retire from that post, my lord.
That goes against the entire aspects of jurisprudence. Then now where you see at least you're entitled to promotions in the entire service.
Just who not.
My lord, they will be, for those who are not entitled for, there is no scope for promotion, my lord. ACP will be there, MACP will be there, my lord. My lord, if my lord kindly goes to page 12 of the writ petition.
1 second.
So these are the posts, my lord, where we were informed that there is no promotional
It does not show.
avenue, my lord.
Now his recruitment to the post of driver wasn't promotion, or was it he was taken as temporarily appointed?
Temporarily,
driver?
officiating, my lord.
No. I mean, no. One thing the court wants to know is that whether that poultry attendance taken into consideration, or just he was just allowed to function as a driver.
No, he was inducted, my lord, into the service as poultry attendant. Subsequently, there was some vacancy which arose in the department, and then he was made to officiate in that post, my lord.
Officiating after that, I was allowed to promotion was
Without
given.
any advertisement. There was no advertisement for that vacancy.
Forget advertisement at the point of time. When was that?
So there was no, my lord, no selection process carried out for that particular post.
That those days, Uma Devi also not applicable, not there.
You were appointed in 81.
81.
My lord, in my respectful submission, my lord, it would be justified, my lord, because we are not making any recovery. That much concession we are giving, my lord.
Recovery you can't make also because
So we are not making, in a sense, my lord, we are not making the petitioner, we are not making him suffer, my lord.
But as per the rules, if the rule,
Because
if there is a
otherwise
breach
we
of
would
any
have,
rules,
we would have pressed for recovery, my lord.
if any rule is violated.
So that we are not doing, my lord. Admittedly, we are not doing.
Yes.
My lord, you'll kindly see there is poultry attendant. On page 13, we have hatchery. And then we have quick attendant.
Take down that. That's it. No judgments. Yes. The petitioner being aggrieved with the impugned letter dated 1st September 19/2020. That annexure?
This is annexure 7. Page 21.
Page?
Page 21. 2-1.
Being aggrieved with letter dated 1st September 2021, whereby he was reverted back to the original post of poultry attendant as per the instructions of the Finance and Accounts Officer on the ground that the post held by the petitioner, that of driver, was but an officing appointment and irregular. Is Twenty 2021, 2020, 2020. Before this court, seeking directions to direct the respondents to extend the benefit of monthly pension as per the pay scale of driver and not of poultry attendant. Stop. The brief facts, next paragraph, are that on the recommendation of the District Selection Committee East Khasi Hills, the petitioner was appointed as poultry attendant on 11/11/1981. In the which department this? Where was he posted first?
Pilot in the veterinary.
Under the respondent number 3.
Veterinary
Who issued upon order? Look.
Well, the original appointment order is issued by
Mr. Qureshi, where's the signature? There's also upon order. There's no last page.
My lord, there is no last page.
Who issued it? Or it's District Selection Committee, yes.
Oh, District Selection Committee.
No? Yes. In the in the central hatchery, cum poultry farm, Naya Bungalow, Meghalaya. Stop. Stop. Thereafter, by an office order dated 12/7/1985, the writ petitioner was allowed to hold the post of driver temporarily under the office of the Assistant Dairy Development Officer, JOY, on a regular scale of pay, including other allowances as admissible, which were to be effective from the date of joining. It appears that the writ petitioner that continued in the said post until 25/3/2015, when his name was forwarded by the respondent, director's phone number, by the office of the respondent number 3. Number 3, for consideration of, sorry. To the district transport officer by the office of the respondent number 3 to district transport officer for conducting an eligibility test to enable the respondent number 3 to consider the writ petitioner for promotion to the post of senior grade driver. Stop. Thereafter, the writ petitioner qualified the set test or performed eligibility test and was found and passed qualified for the set test, and a certificate dated 6/5/2015 to this effect was issued by the Office of District Transport Officer, Libhoi District, Nongpor. The petitioner then was granted promotion on 13/10/2015 as per the recommendation of the Departmental Promotion Committee held on 17 September 2015. She was given with effect from 1/1/96, the promotion. Mr. Qureshi,
yes, sir.
What a promotion to the post senior driver for which effect, which date?
Date of joining, date of promotion, grade 1/1/96.
You sure?
Date of promotion to senior grade drivers. Here written.
Yes.
Number 2, 1/1/1996.
Tumda? To the post of senior grade driver on a regular scale of pay with effect from 1/1/96. The 96. He retired on?
He retired on
39,019.
Yes.
Until now, not been paid pension.
30th/9/2019.
Yes. The petitioner superannuated, then superannuated on 39/2019 after rendering how many years in service? 81,019? 81 to 2000, how much? 19 plus 19?
19 years. 81 to
Yes. You have to take out a calculator. 38 years in service.
38 years.
Yes, he's in service. But however, his pensionary, his pension, that is now not released.
My lord, only difficulty was, my lord, this calculation.
What calculation?
My lord, the
But his
finance
pension,
department.
but his pension
Finance department
Once, my lord,
was not
the
released.
No release, yes.
the finance department
Has
says
not been
that-
released till date from the date of superannuation due to the objection which is contained in impugn letter.
My lord, because fixation will have to be done by the finance
Yes.
department.
Next paragraph. Ms. M.F. Kurushi, learned counsel for the petitioner, has submitted that the said petitioner, though joining as a poultry attendant, was by due process allowed to officiate against, was allowed to temporarily hold a post of driver since 1985, and thereafter had retired as senior grade driver. He submits an entire length of service. No query or no objections that have been raised with regard to release, with regard to his fixation of pay, and also his appointment, his initial appointment, and subsequent promotion by the concerned departments. He submits that, he further submits that it's only after the petitioner has retired that the objection has been raised, which has resulted in the deprivation of his pensionary benefits since 2019. Stop. It's also been contended that at the point of time of the appointed petitioner, there were no rules governing the field, and as such, there is no impediment to the respondents to process the pay settlement or final pay of the writ petitioner for computation of his pension as admissible. Stop. Next paragraph. Mr. Kiwi Varasaji, in reply, had submitted that the rules do not provide for a poultry attendant to be promoted to the post of driver, right? And that the promotion, that the officiation of the officiation of the writ petition against the post of driver and subsequent promotion was highly irregular, which is now being sought to be corrected by reverting the writ petitioner to his original post and for calculation of his pension as admissible pay thereon. Stop. He therefore submits that, he further submits that as the irregularity is not attributable only to the writ petitioner. After the last pay is finalized, no recovery will be undertaken by the respondents for any amounts that may be calculated to have been overdrawn. Stop. Next paragraph. Further, counsel for the parties have considered the submissions and peruse the materials on record. Firstly, it is noted that in the case concerning the petitioner, at the point of time of his appointment and subsequent, at the point of time of his initial appointment and subsequent appointment as driver under respondent number 3, the Meghalaya Ministerial District established, there were no rules applicable. Stop. This has been also concurred to by the learned GA, learned common advocate, who fairly submits that the rules relied upon by the respondents at this stage are the, within quotes, the Meghalaya Ministerial District Establishment Service Rule 2017. Stop. This matter, it may be added, it may be observed herein, it may be noted herein, had been adjourned repeatedly to enable the state respondents to come up with executive instructions or any other materials to show as to how the service of the writ petition was regulated and whether the temporary appointment to the post of driver and subsequent promotion was per se illegal. Stop. Today also, the learned government advocate has expressed his, today also government advocate has expressed to the court that no materials could be obtained in this regard. Stop. Next one. In view of the stated facts as narrated above, and also in view of the fact that the writ petitioner, though appointed as poultry attendant, was thereafter allowed to temporarily hold a post of driver and retired as such on promotion, the service benefits on the services rendered by him for the long years from 1985 till 2019 cannot be denied. It is settled law that an appointment, whether temporary or permanent, that a person appointed temporary or permanent cannot be reverted to the post from which he was promoted. Stop. Even taking to be the promotion from poultry attendant to driver, even if it's taken that the temporary engagement of the petitioner as driver from poultry attendant to be irregular, in the considered view of the court, in the absence of any rules, this appointment has cloaked the petitioner with a right to claim his service benefits as paid. Stop. Accordingly, the writ petition is allowed, and the respondent directed to settle the pay, to settle the what will be the in this the petitions allowed, and the respondent directed to approve
the initial pay statement,
to approve the pay statement of the writ petitioner on the amount he was drawing on the date of his retirement, and to fix the pension as payable thereon. Stop. Consequently, the impugned order dated 1st September 2020 also stands set aside unquashed.
Only one small request, my lord. My lord, this may not be a precedent. Otherwise, it could open a
yes, it
cascade
has,
of litigation.
due to the peculiar situation of the case, this case may not be taken to be precedent in other matters where if instructions exist or rules available for consideration consideration of services, yes, of other persons. Yes.
Item 22.
Entire exercise shall be complete in a period of 2 months.
2 months.
From the date receipt of this order.
May I pray for 3 months at least?
He's from 19 till now. He's starving.
My lord, only
I hope
difficulty
he's not
was
dead.
fixation of pay, my lord.
He's still alive.
He's just working as a daily wage laborer.
My lord, only difficulty was
After retirement, he's going daily as a laborer.
Yes.
Only difficulty
Then
was
should we
the
give
fixation.
compensation also then?
My lord, only difficulty was with regard to fixation, my lord. Had he agreed to the reversion, my lord?
Why should he agree? When he is drawing, suppose 100 rupees, you want to fix at 20 rupees and fix pension out there. You want to kill him also after taking his services.
And my lord, there is a similar case already happened in the department also. My lord.
Similar case, that's the court. Yes.
22.
Obliged, my lord.
This matter going to fixing the substance of law. It's already come. I thought
Yes, my lord. Yes.
Court will do it. Listen, after 1 week.
Okay.
Sorry.
Yes.
Escape my notice. Yes.
24.
Your Lordship. Lordship, I can pray for 1 week's time, Your Lordship, on this matter.
4 weeks time?
1 week's time, Your Lordship.
Where's the petitioner? Will dismiss for default. You informed him?
No, Your Honor.
You didn't inform him?
No, I didn't have his number. I didn't see him this morning also, Your Lordship.
Well, he knows that. Yeah. You know the facts of the case.
This is about the maintenance, Your Lordship.
Okay. None appears for the petitioner. List the matter after 2 weeks. Yes.
Much
1 week.
appreciated.
1 week.
Much obliged, Your Lordship.
27.
Lordship, I pray if this matter can come up after 2 weeks, Lordship.
You ready with the matter? No, okay. On the plea of Sumpanhan, it's a matter of 2 weeks due to the absence of CGS, DGS, IS.
Highly obliged, Lordship.
28.
Get to record the case.
Lordship, this is a case where the petitioner was discharged from service
Yes.
on the ground that he contracted plural marriage.
Contracted?
Plural marriage.
Yes.
Lordship, before I start, maybe allowed to refresh your Lordship's memory.
Yes. The door, you ready?
May I, Lordship? Lordship, the brief fact of the case is that the petitioner he's enrolled in the Assam Rifle as recruit GD in the year 2003. Now thereafter in the year 2005 he was remustered as Rifleman GD. Now in the year 2006 the petitioner was transferred to Assam Rifle Unit Tripura, whereby he has served till 2010. Now in the year 2010 the petitioner was posted at Assam Field Investigation Unit in Shia Region.
2010?
2010, Lordship. Now thereafter, Lordship, after 2 years of service, then in the year 2012, the petitioner got married to one Ram Kumari, who is the legal wedded wife of the petitioner, Lordship.
Ram Kumari?
Ram Kumari. Now, Your Lordship, thereafter, the petitioner, in the month of September 2014, he was informed by his unit that there was a complaint by one lady, that is Indira, who claimed to be the second wife of the petitioner.
Yes.
Saying that he has failed to provide maintenance to this lady, to the so-called second lady, second wife, Your Lordship. Now to that effect, Your Lordship, the second wife, the so-called second wife, has also filed an application for maintenance before the court, Your Lordship. Now thereafter, Your Lordship, on 16/12/2014, the CR matter, the complaint matter, was disposed of on settlement between the parties. Now,
That means the marriage is registered with the second lady?
I'll come to that, Your Lordship. Lordship, may kindly come to Annexure 1. Annexure 1 of the petition, writ petition.
Yes.
Now, Annexure 1 of the writ petition, this is the order in which the complaint case under 125 was disposed of on terms of the settlement.
Yes.
Now thereafter,
You agreed, you're paying till now 5,000?
No, Lordship, I had stopped long time back, Lordship.
But compromise deed, you say that the respondent agreed to pay monthly maintenance.
No, because at that time when I was transferred to a different unit, Your Lordship, then because of then it has stopped, Your Lordship. The maintenance was discontinued.
Yes.
Now thereafter, Your Lordship, then since the petitioner came to know that this so-called second wife has claimed to be the second wife of the petitioner, now he had filed a divorce suit before the Additional Deputy Commissioner, titled Divorce Suit 35T of 2015. Now he has filed this divorce suit in the month of August 2015.
Yeah, then what order was passed?
Then, Your Lordship, after the divorce suit was filed by the petitioner in the month of August 15, now this lady notice was issued to this so-called second wife. Then this lady never appeared before the court, Your Lordship. Now,
no, what about this annexure?
Lordship.
3. Page 30, what is this?
Page, no, Lordship.
Page 30, what is this?
Page 30, Lordship, initially what happened is the petitioner in fact has filed a divorce suit, contested divorce suit, before against the so-called second wife.
Yeah.
Now since she failed to appear, Your Lordship, so this petitioner had approached the so-called second wife for settlement, Your Lordship. Now thereafter settlement was arrived between the parties. And that divorce suit, contested divorce suit, was converted into a mutual divorce suit. Lordship, may kindly see Annexure 3, page 30. The Lordship, may kindly come to page 31.
Yes.
31, the order. Lordship, the date of the order is 31/10/2016.
Yes.
An application under Section 27 Special Marriage Acts also for dissolution of marriage between the petitioners and also against Indra Roy, and the same is registered as divorce suit 35T of 2015. So initially he had taken steps, Lordship, for dissolution of marriage, and since she failed to appear, Lordship, there is certain settlement will happen between the parties. Now this contested divorce suit was converted to a mutual divorce suit.
Okay.
Now, in that event, Your Lordship, the application for mutual divorce was allowed, and a decree also was drawn. Now that decree will find at Your Lordship will find it at Annexure 4.
Yes.
Now
Where is your first wife all this time?
She's there, Your Lordship, in her village.
Okay.
Now before this order was passed, Your Lordship, the Assam Rifle, relying on the complaint filed by the so-called second wife, they initiated a court of inquiry proceedings against him. Now that court of inquiry was initiated first on 5th August 2016. Lordship, kindly mark the date, Lordship.
No, where's the 5th August 2016? Where's the okay, 5/8/16.
5/8/16.
Where is that?
Lordship, I'll come to that. Lordship, kindly come to page. Can you come to page 59, Your Lordship? The impugn order, page 59. Annexure 12. Lordship, the second paragraph.
Type copy is not there.
I'll read, Your Lordship. Para 2, Your Lordship. Whereas number so and so and so is reported to have
This
contracted.
order is 23rd May 2018.
2018, Lordship.
Page 15 is.
Yes, Your Lordship. I'm reading this order dated 23rd May 2018. I'll show the reference to that.
Okay.
The second para, Your Lordship. Whereas number so and so is reported to have contracted plural marriage during the lifetime of his first wife, Ram Kumari, without taking legal divorce. Accordingly, a court of inquiry was convened in regard White so and so convening order dated 5/8/2016. So in the year 2015, the petitioner has already taken steps to divorce the so-called second wife in the year 2015, August 2015. Now thereafter, Your Lordship, the court of inquiry proceeded only on 5/8/2016.
But the decree was given on?
Your Lordship, the mutual
Decree was
divorce
given on
order.
31/10/2016.
No, that is the order, Your Lordship, 31/10/2016, and the decree is 22/11/16.
Okay.
So the order of mutual divorce, the degree of the mutual divorce happened during the course of the inquiry proceedings. Now this information has been given, has been stated by the petitioner before the court of inquiry. So the court of inquiry is well aware that there's a divorce suit filed by the petitioner in the year 2015. The court of inquiry is also aware that there's a mutual divorce filed by the petitioner and the so-called second wife. And the court of inquiry is also aware of the fact that there's a mutual divorce, there's an order of mutual divorce for dissolution of a marriage, and this is also a decree drawn by the learned court, Lordship. Now, after Your Lordship, after the decree was passed, the petitioner fairly participated before the court of inquiry, and his statements was also recorded.
Yes.
Now, Lordship, during the preparation of this matter, it's Lordship, those statements I could not brought on record.
So you took part in inquiry.
Part in the inquiry. Now my statements were already recorded. Now the court of inquiry has also raised question as regard to my divorce. What is the status of my divorce petition before the court? And the court of inquiry is also aware that there was a decree and there's an order of dissolution
But
of
the fact
divorce.
remains that during subsistence of the first marriage, you entered into a second marriage, right?
Lordship,
and that is you violated the rules of Assam Rifle.
Our ground is that since the marriage itself is invalid, not valid in the eyes of law, Your Lordship. That was the ground taken before the Court of Inquiry.
So you have precedents to show that if a marriage is invalid in the eyes of law and second marriage contracted, and then the rules will not be attracted.
I have
to
one
say
judgment.
That's plural marriage.
I have one judgment on that plural marriage. Your Lordship,
Where-
before coming
where
to this,
it allows. So okay, fine. You got married by mistake, so it's condoned.
Lordship, I'll come to that judgment, Your Lordship.
Okay.
Now, after I've participated in the inquiry, Your Lordship, Court of Inquiry.
Yes.
Now the Court of Inquiry gives its finding an opinion.
Where
Now
is
that
that?
opinion and finding was never communicated to me, Your Lordship. So I am not aware to what is the finding. Now straightly after the completion of the inquiry proceedings, now the Assam Rifle has issued the show cause notice on 16/9/2017, Lordship. Can you mark the date?
Where?
The impugned
This
show
is-
cause. The impugned show cause
16
notice
September.
is Annexure 5, Lordship. Yes. Annexure 5 is the show cause notice. Page 43, Lordship.
Yes.
Kindly mark the date, Lordship. The show cause notice is dated 16 September 2017. May I read the show cause notice? I have perused the findings of opinion of the court pertaining to Court of Inquiry proceedings which is held to the circumstances on which you have contracted plural marriage with Mrs. So, Lordship, I'm not privy to the findings and opinions of the Court of Inquiry. Number 2, I have observed that you have contracted plural marriage with Mrs. Indira Ray when your wife so-and-so is alive, which is against the rules and policies of Assam Rifle. 3, as per the directions of higher headquarters, as so-and-so need to be initiated against you in accordance with Para 10.2 of Assam Rifle Rule 2010, which states that you are eligible to retention in service. You are therefore afforded this opportunity to explain the defense reasons on the above account as to why your service should not be terminated under the provisions of Section 1.2 of the Assam Rifle Act 2006 and Para 10.2 of the Assam Rifle Rule 2010. You should submit your reply to this show cause.
So this Court of Inquiry, you took part?
I took part, Your Lordship. I took part. But the finding and opinions of the Court of Inquiry were never communicated to me. So I am not aware to what is the
But you
finding.
asked to show cause against. Then you show cause against what?
This I show cause, Lordship, to this.
No, I mean, is the findings of opinion, but then is it incumbent upon them to give you a copy of the Court of Inquiry proceedings?
Lordship, as per Rule 187, it's not mandatory.
Then?
But what I'm trying to say, Lordship, since
even then
before
they've
the
given
Court
you a
of
chance, they've given a chance to, it's like a second show cause. You see,
It's
they
like a
already
second show cause,
It's like a
Lordship.
second show cause. They
Yes.
initiated the inquiry against you already. Now they've looked at the findings. It's not mandatory for them to supply a copy to you. But they've given you a show cause notice on 16 September saying fine show cause.
Lordship, what I'm trying to say is that at the time when this show cause notice was issued to me,
there was no marriage subsisting.
There was no marriage subsisting.
No, but
marriage
can,
has already
can
been
that be a
dissolved.
case? Suppose you committed a crime. Can be washed away by any, even it's compounded, like will the fact that you had committed some, suppose, a compoundable offence, can that be erased from your record?
Lordship, what I'm trying to say is that before the Court of Inquiry, I have taken all my grounds. Now those statements are not
So
before
whatever it is, Mr. Nompu, suppose, suppose you present yourself for employment or recruitment to certain posts, where you have to give your antecedents and with regard to whether you have ever involved in any criminal offence or convicted or acquitted, whatever. Now suppose, looking to antecedents, if your recruitment rules not allow, such a thing, that a person would be employed. Now even suppose that if that thing was compounded, that whatever you did is compounded, suppose the offence. Will you say that will overcome the rules? As Assam Rifles have, plural marriage is not permissible, correct? And so do you think that by the fact that that marriage was invalid and it was invalid as you say, and then it was dissolved on mutual consent, that will be erased from your record totally to make that
What I'm trying to say is that the court of how does the Court of Inquiry comes to a conclusion that this marriage is a valid marriage?
How?
Lordship,
if you go for divorce, what inference can you derive from there?
Lordship,
Why should you go for divorce then if you never married?
Lordship, the first divorce was a contested divorce.
Exactly.
2015.
Yes. Contested divorce on what ground? You filed for divorce, correct?
I filed a contempt.
Then?
Because our ground is that the marriage was obtained by fraud, Your Lordship. So that's why we are taking steps.
Obtained by fraud?
for dissolution of marriage.
Why do
Undo
you-
statement
Okay,
are,
factually coming to, okay, we're not on fact in your case, but factually what really happened? Why did you go and contract a second marriage or any kind of relationship with a second woman?
Lordship, rightly or wrongly, perhaps there may be a second marriage, Lordship, but our stand is that that marriage is
Will not
void,
count.
Lordship.
Will not count towards, will
not
not
count
count towards any offence under the Assam Rifles rules.
We are saying that the penalty imposed upon me is quite harsh, Lordship. Lordship,
No, but as
what
per,
I'm praying, Lordship,
as per Assam Rifles rules, if I'm not wrong, that means once you contract a second marriage, you'll be ineligible to be, to continue in service.
no, Lordship, what I'm trying to say is Lordship, the Court of Inquiry is well within the knowledge, the facts that that there was a divorce decree, that there was a divorce filed by the petitioner in the first instance in the year 2015, a contested divorce. Now, all these statements are not before your Lordship, the statements before the Court of Inquiry.
You've received them now.
Lordship, I've received some of the statement,
What
but
do you say?
the entire records do apply to me, but it's not not eligible, Your Lordship.
Not legible, why?
Not legible.
a different
I
language.
don't understand, Your Lordship. That's why in our show cause reply, Your Lordship, we are categorically stated that you provide us a clear copy so that we can give you a clear reply to your show cause. Now, Lordship, my submission at this stage, Lordship, may you kindly please call for the records of the Court of Inquiry. Lordship, may kindly see the statement made by the petitioner before the Court of Inquiry.
Oh, now in the show cause it reveals. I proceeded on so and so. Sometimes I was going to do some taekwondo, and then so you're a martial arts exponent.
Lordship, how this marriage come into being?
So you met this lady while doing martial arts only.
Lordship, that is the.
Okay.
Annexure 6 is the interim show cause, Your Lordship. Then Annexure 7 is the final show cause filed by the petitioner.
Show cause is highly unbelievable. Anyways, you're fighting a tough case. Anyway, we'll give you. Yes, but Devnath, any purpose will be served by bringing the records of the court of inquiry?
You should come to this petition, page 44.
Yes, 44 I've seen.
In this it is a clear admission also. And moreover,
yes, in the show cause, in the reply also see there are two replies, correct?
Yes, Lordship. Annexure 6 is the interim reply because the legible copies was not supplied to me. Now, Annexure 7 is the final show cause reply. In the first para itself, I have stated that these documents supplied to me are not readable.
So you want another chance to show cause?
No, Lordship. What I'm saying is that, Lordship.
But see what you've written here. What you've written here.
Second para of the show cause, Lordship. I beg to say that many of the documents forwarded to me are.
See, look at this on page 47, second half paragraph. On 27/5/2014, she called me and told me that she was going to court to do some work and requested me to help her by accompanying her to the court.
Yes.
As a courtesy, I accompanied her to the court, but she took my signature on some papers, saying they needed as a witness only. Since I was on duty and had to report back to so hurriedly, I signed those papers in good faith. I could not even dream of that she would utilize these papers of obtaining marriage registration certificate for establishing my legal marriage to her. Come on, I mean, that is,
Lordship, may kindly see the marriage certificate also. And the complaint that the so-called second wife, she claims that the marriage had happened had ceremonialized before the temple, Your Lordship. Now there is no evidence to that.
So, Your Lordship, marriage certificate is in my reply.
There is a marriage registration certificate, Your Lordship.
Exactly.
Page 14.
How did
page 14, my
page?
Page 14, 1/4. The marriage certificate is
Yes.
with the register.
Lordship, kindly come to page
What is
30.
witnesses also produced for the court inquiry? Yes,
No,
Safraz
there's no
Ahmed.
witness, Your Lordship. The witness are the officers itself from the Assam Rifle and the petitioner himself.
In your marriage certificate.
Lordship, this marriage certificate was never questioned before the Court of Inquiry. No evidence on this.
The certificate is admissible.
Lordship, kindly come to page 13. Kindly come to page 13, Lordship. Page
You
13.
took a photograph together also. What is this?
Kindly come to page 13, Lordship.
Seen marriage certificate.
Lordship, I've seen that. I've seen that as a joint photograph.
Your tough case of fighting, but will anything be achieved by calling for the cause of court inquiry?
Lordship,
What is
just to show the bona fides of the petitioner, Lordship. Now, page 13, Lordship, this is a complaint to the Assam Rifle. This is written by that so-called second wife.
Page?
Page 13, 1-3.
Of the writ petition?
Of the affidavit in opposition filed by respondent. Now,
Yes.
this is a complaint which the so-called second wife had written to the Assam Rifle.
Yes.
Para 1. That I got married with the above named person on 23/4/2015 in Mahadev Kola Mandir, Shillong.
Yes.
There's no evidence on that, Lordship.
Registered after that.
And thereafter,
our marriage will register on 27 May. That's only
Lordship,
after on next month.
solemnization and
just 1 month.
registration is two different.
No. Once you this will hold weight. Once you register, if you see only marriage in temple, questionable. Now I come to know after marriage he's already married and he's got a wife in his native place. He has concealed the fact and he concealed the fact and married me saying he's not married. That's an old ruse many people use, servicemen especially.
Lordship, my humble prayer at this stage is that the records of the Court of Inquiry be called for.
That's now he's
just
not
to show
willing
the
to keep
bona
me as
fides.
wife, not willing to pay me maintenance. That is brought first wife to Shillong, so that's why he wants to,
Now, this lady was never also examined by the Court of Inquiry. She
Why
was
should we
never
examine?
called.
This marriage certificate has sealed the deal, like they say.
Lordship, but there's a divorce decree. So far as now, when the show cause notice.
Authority you have? What authority you have? Where are the rules, Mr. 10.2?
10.2 is annexed in the writ petition, Your Lordship.
Where is that?
Page 54, Your Lordship.
Yes, sure. Listen, what authority do you have?
Lordship, this is a judgment whereby the Rajasthan High Court has come to a conclusion that the disciplinary authorities cannot as a court under the Hindu Marriage Act to decide whether the marriage is legal or not legal.
Your marriage is under the Special Marriage Act.
Lordship, my case is
There's
that
already a marriage certificate, you move for divorce,
Lordship,
then
can you
mutual
come to-
consent of divorce. What other proof do you need?
Lordship, kindly come to para 12. 12 and 13 of this judgment.
Yes.
Even assuming that the show cause notice and the inquiry conducted by the Court of Inquiry was sufficient compliance with the principles of natural justice was on the same facts and allegations.
Okay, you prove the records, we'll see whether you write a certificate. If you write a certificate, your case is over.
Lordship.
You produce it. Here's the findings. The findings you have with you.
We are not supplied with the findings.
Yes, the final court inquiry only. Yes, in the course of hearing, Mr. Ahmed Nompur, learned counsel for the petitioner, has submitted that the findings of court inquiry have not been provided, have not been supplied to the petitioner to enable him to file a complete show cause on the earlier occasions. So he submits that though it is not mandatory for the respondent to supply the copies of findings in the instant case for the purpose of determination as to whether the finding was based on the marriage certificate, the same and necessary to be brought for the court. Stop, Mr. Debnat. You don't object, no? Don't object to the same. Stop. Let the findings of the court of inquiry.
Lordship, I'll pray not just the finding, the entire records, because my statement, I want to show your Lordship the.
Your statement doesn't have no value because it's on documentary evidence.
Lordship, there was a questionnaire between, there was a cross-examination between the.
What cross-examination? You got married?
Lordship, I just want to.
Well, doing taekwondo.
Lordship, even
that's your own show cause. You said, well, I was doing taekwondo and I met this girl
These are the
doing
facts.
martial arts
These are
and
the
this
facts,
and that.
Lordship. Lordship, the entire records, Lordship, because the statement is important, Lordship, for
Of course, the
adjudication of
records,
the matter.
yes, and also the findings of the court inquiry. Yes. This up to 2 weeks.
Item 30.
Please, Your Lordship.
Yeah.
Your Lordship, here the instance case is related to the illegal appointment, Your Lordship, for the post of the assistant teacher in Kandargaon SSA school. The post of the assistant teacher was filled up without any advertisement, Your Lordship, while the respondent number 7, who is the private respondent, was appointed for the said post without having the requisite qualification, Your Lordship.
Why do you say that? Why do you say that doesn't have requisite qualification? As per, he doesn't have MTET.
No, Your Lordship.
What does he have?
The requisite qualification for the appointment of this post, which is the LP school, it's in annexure 8 of my plan news.
Annexure?
Pre-petition of my.
Annexure 8?
Page 23.
Okay.
According to the National Council for Teacher Education norm, the requisite qualification is senior secondary with at least 50% mark and 2-year diploma elementary education.
Yeah. Where are you reading from? Secondary, senior secondary or equivalent with at least 40% marks and
Yes.
2-year diploma in elementary education.
Yes, Your Lordship.
Yes.
And even the
problem is DLED.
DLED.
Okay.
Your Lordship, this appointment was totally.
Where's the point of the respondent number?
7.
7. Where's the appointment order? His name
Appointment
is.
order was in.
Page 19.
Yes, Your Lordship.
This is a case of land donation.
Land donation, Lordship.
Yes, have you
This
seen
father-
what's the memorandum regarding land donation? You've annexed that in your affidavit.
No, my lord. My lord, more or less, we're favoring the petitioner, my lord. Our affidavit is in favor of the petitioner.
Why?
What happened here is, my lord, the family of the private respondent have been landowner on which the school was constructed. His father was working in that post, my lord. So he died in harness. So subsequently, my lord, the school managing committee on their own, they decided, the resolution is made part of my affidavit, my lord, they decided that the one member of the family should be appointed. So, my lord, when the decision was made, the private respondent never had the necessary qualification. So he was, my lord, 2 parts of the resolution, my lord. 1, to give an employment to the family member who have donated the land, and number 2, that he was given 3 years' time to have that essential qualification.
Obtain certificate, yes.
At the date of, my lord, appointment, the decision, he doesn't acquire the qualification, my lord. So to work as a teacher, my lord, assistant, he does not have the qualification. And, my lord, this resolution was of the school managing committee, my lord.
Not
And
approved by you.
No, my lord. So managing committee has decided to appoint him on their own, my lord. So, my lord,
But then
he
what
does
about
not have.
this 31/3/2021? That annexure F4.
And, my lord, the petitioner also gives an undertaking that he will acquire the necessary qualification. But, my lord, in that period, he was allowed to function as a teacher of the school, my lord, which was.
After that, he didn't obtain.
No, my lord, subsequently he must have, my lord. Now he has it. But at that time, he does not have. At the time of appointment.
Yes.
But subsequently, I've acquired DLED, my lord, and I've set for the MTET exam, but I am unsuccessful, my lord. So I'm
for the next MTET.
And my lord, one more important thing, my lord, there was no proper advertisement, there was no recruitment process, my lord, conducted.
No, but the things are, see, if you're a donor in a school, there's a
My lord, there is.
offering with regard to PHE and this and
My
that,
lord, yes, grade 4 services are provided, my lord. 2007, my lord.
That
Summer
memorandum.
7, my lord.
Where is that? Is here.
My lord, I don't see, my lord.
Produce that memorandum, Mr. Basumatari.
Your Lordship, memorandum is
But my lord, in the context of teacher, my lord, that will be a matter of qualification.
Exactly. But then we have to see memorandum first, because if it's special recruitment regarding advertisement, whether if the person possesses the
Yes, my lord.
qualification and if
Then
the
in that
memorandum
case, my lord,
allows
that
that
can
it
be an
donated the
additional-
land then to
My lord, yes.
offer a post, subject to eligibility, of course.
Yes, my lord, that is
That's what-
that
so
is our
advertisement
contention.
part can be done away with. That's only
My
what
lord.
the
My lord,
school
that
trying
is
to
what
say.
we have also stated in our affidavit. If this person had the qualification and subjected they were the landowner, my lord, there should not be any difficulty, my lord.
Where's the memorandum?
My lord, at Annexure 5 in my counter affidavit, my lord. Page 20, my lord.
Page?
Page 20, my lord. Page 20, my lord. May I read, my lord?
Yes, 1 second. Yes. Grade 3, grade 4 post, not
My lord,
teacher.
yes.
But
Yes,
my
my
case is on a special category, my lord. While
So
my
you have to be
father-
reverted to grade 3 post then.
My lord, there is no.
Instead of being
grade three-
teacher, you
my
have to be
lord-
Safai wala.
My lord, kindly
Then?
appreciate this aspect, my lord. This is an SSA school, my lord. Only 2 sanctions posts. There is 2 teachers, my lord. And my father was serving as the head teacher, my lord. My lord, only there's 2 posts and there is no grade 3, grade 4 post. Which is why during the
Where's the
pandemic-
memorandum? You produced it at 2014?
My lord,
17, my lord.
17/11/2014. Is here.
My lord,
There's only a letter, not a
yes,
memorandum.
my lord, that original memorandum, my lord, I have not annexed, my lord.
You produce it.
My lord, if kindly see, my lord, the resolution passed by the SMC.
We won't look for resolution. Let's go to the basics.
And the,
Basics of the
litigation
case first.
coordinator.
If the memorandum allows some kind of relaxation, but you see, where it's only for grade 3, grade 4, whether he can extend it to include teachers also.
My lord, then, my lord, diesel.
Because usually in all these cases, it's only we've given some clerical job.
My lord.
In the school, there is no clerical job, my lord.
Why?
No, because the SSA school, my lord, only 2 sanction posts. They are getting only lump sum amount. So 2 teachers. my lord.
Managing committee can pay for no resources.
That is the one.
They're running a free school, no
The
fees.
Managing committee has no source of income, my lord.
No fees.
No, on hardly a fee, that is, I have to get instruction, my lord. Because managing committee has not yet appeared in this matter, my lord. So notice has been served.
Why? It's got ex parte against them.
My lord.
Notice has been served. Lord.
Notice has been served at the managing committee. They have not appeared, my lord.
How is that possible?
Yes, my lord. Respondent 6, my lord. Managing committee of Kandargaon SSA school, represented by its convener. They have not appeared, my lord. As per my humble understanding, my lord, all the schools in.
So they've thrown you to the wolves to fight your own battle after appointing you.
My lord. In most of the schools, my lord.
Have they received notice?
Yes.
No, petitioner in the position.
You see, the thing is that, they have received notice.
Yes, yes.
Where is that?
I have already filed an affidavit.
Whether it's
Service
the right
of
person or
notice.
not, yes?
Yes, I have already filed a service of notice.
Where is that?
It was filed on 6 July
Okay, 1
2023.
second. When? It goes to send to the office only. You do one thing, since it involves his, he might be deprived of his post. Can you take personal service through the? You can help.
Yes, I can help.
Yes.
He's in the school, my lord. He's working. Definitely he can help.
Of course, that's what this court does not want to say that should do it. Yes.
I'll help.
For your son.
Yes, no. Though a service affidavit has been filed, as indicating enclosing a service strip, enclosing the delivery information showing that respondent number 6, that is the managing committee of Kendaragaon, Kendaraagaon, West Garo Hills, Fulbari, had been served notice. No appearance has yet been made on their behalf. In the instant case, the presence of the said managing committee is necessary, in as much as what has been called into question is the appointment given by the said managing committee to the private respondent. Petitioner to take fresh steps on the respondent number 6, assistance of the respondent number 7 also. The respondent also volunteered to assist on service and to provide a copy of the petition to the convener of the managing committee just after 2 weeks. We'll give a copy to him. We'll get sponsor service. Otherwise, managing committee is necessary. On what basis they appointed?
32.
Hello.
32.
They have thrown you to the wolves to fight your own battle. They don't care. Yes. For the petitioner, item 32.
Yes, Lordship.
What's the matter about?
This is a case, my lord. I have been recommended for appointment, the post of professor, my lord, assistant professor.
In which college?
Shillong College.
But where's the arguing counsel?
Senior counsel is having difficulties, Lordship, today.
He is not in Shillong.
Many adjournments, your lordships. Only thing, my lord, next day we can, my lord, finish it. Well, the only issue I am raising here, my lord, UGC norms, there is no minimum slab for, my lord, age.
That's correct.
Entry level. So she has not filed any affidavit.
I have not filed any affidavit, but I'll just be relying on the rules.
Because I am also relying on different high courts where they.
Shillong College.
Yes, Lordship.
Respondent number 9.
Was appointed in his place.
Yes, sir.
10 is? Oh, it's not necessary actually.
And 11 is UGC. I'm appearing for 11.
But my lord, if I can pray only one thing.
Yes, Mr. Sen.
Whatever, my lord, here entire crux of the issue depends on the, my lord, UGC, my lord, whether there is any restriction in the entry level, your lord. So since my learned friend has not, for UGC has not filed any affidavit, my lord, that affidavit would have helped us. And it's because I have come across.
It's the rules only which will be.
No, it's sorry. If it is because I have come across.
Mr. SN, learned counsel for the petitioner submits that though prayer for adjournments has been made on behalf of the respondent number
4 to 8.
Number
4 to 8.
Number 4 to 8, and on behalf of respondent number 9 and 10. Mr. SN has submitted that since the crux of matter CRUX hinges upon the prescription of UGC as to eligibility for the post, an affidavit by the UGC would serve the purpose of clarifying the entire issue. You take instructions. However, MSP Agarwal submits that since the same is based on rules, production of the UGC rules itself would suffice. So, however, he's directed to obtain instructions as to whether affidavit be necessary or not. This up to 2 weeks. You file affidavit then.
33.
This matter, my lord, was heard on the last date. It is regarding appointment of assistant headmistress, and the managing committee has sent the recommendation to the directorate for appointing the petitioner as the assistant headmistress. So my learned senior had placed on record the 2010 rules, Meghalaya School Service 2010 rules, wherein it was stated in the schedule that for being appointed to the post of assistant headmistress, 8 years of service is sufficient. But my lord, I have sought instructions from the department, and the 2010 rules have been repealed, my lord. And
when
they
were
have
repealed?
repealed in 2012. This is the 2012 rules, my lord.
So under 2012 rules, what does it say?
Under 2012 rules, my lord, if your lordship kindly comes to schedule
Are you
1,
aware of this, Mr. Islam?
No, I am not aware.
Then you kindly give him a copy.
my lord, I'll forward it to him.
Yes.
Schedule 1 at page 11, my lord.
Yeah. Schedule 1 at page?
Page 11, my lord.
11, yes.
The senior school service grade 1 for assistant headmaster or headmistress. Sorry, my lord, this is the pay scale of pay. The schedule 2 is the eligibility criteria.
Vice principal.
Vice principal or assistant headmaster, person eligible for consideration, assistant teacher, and educational qualification, if your lordship comes to column 5, degree with B.Ed and 8 years of continuous and satisfactory service. In the instant case, the petitioner has not completed B.Ed, my lord. So he's not eligible, she's not eligible
Take
for...
down, pursuant to order dated 22/3/2024, Ms. P. Agarwal, landed GA for the response 1 to 3, has come back with instructions and submitted that the Meghalaya School Education Service Rules 2010 have since ceased to operate, and in their place, the Meghalaya School Service Rules 2012 has been brought in and are in force. You sure they're in force now?
Yes, my lord.
Yes, Mr. S. Islam, please allow to peruse the same. When? Just after 2 weeks, yes. Copy of the rules taken on board, yes.
I've handed a copy of the rules.
34.
You look at them. Yes. Yes.
Wait, please, Your Lordship. Milord, before we go into the actual issues, Milord, may I submit that we may just recapitulate Vishaka's case, Milord. Vishaka's case. May I take Your Lordship to Vishaka's case? Certain.
Today we have time, I think, Mr. Roti.
It will take a little time, of course.
Very unpleasant little case also.
Of course, Milord. Needs a little.
Only the domestic inquiry has been initiated. So he is free to participate, my lord, whatever objection he can raise.
In fact, Mr. Koti, I used to chair this.
My lord, I know, I remember.
Cell in
I remember, yes.
Very unpleasant.
Right.
Yes.
Well, if it may come up after the 10th of April.
After?
10th of April. Today is
after a month.
Sorry, 10th of May.
Okay, yes. Records not necessary, right?
Well, only the thing is that ICC report has not been submitted. Anyway, we'll go into that.
Yes,
if required.
request of the council, senior council, this matter. You're traveling again after 10th May. You're frequent traveler, huh?
Medical issues.
Oh, okay. Right. That's it. Thank you.
All right.